Let's bring in our guest to discuss. Defense attorney and former head prosecutor, friend of the program, Bob Bianchi. What stood out to you in this exchange? Because the judge, wow, he's a good judge, and he's very patient, and he was trying to explain to Ms. Vallow once again the fact that, yes, you can do your discovery, but I don't think it's going to be coming in by the end of this trial. We told you that, which is the reason why we said maybe you should keep your attorneys and not do speedy trial.
Yeah, I guess I'm going to take a little bit of a different look at this, guys. I mean, you have a woman who is facing multiple, or is serving sentences for multiple murder convictions in which she's going to spend the rest of her life in jail. So she has an opportunity at a trial here to have some fun, to kick the tires, to be the center of attention. And I've said this before, and I know it's a contrarian view to most of the analysts that are on here. I think she makes good arguments. I mean, I think she presents arguments that the judge is going to have to be careful and listen and not jump to conclusions, which is an easy thing to do with a pro se defendant, because my experience has been sometimes a small pebble can overturn a large carriage. And if you discount her and you're not methodical on how you explain discovery issues, for example, the Cellbrite, I kind of sympathize with this. I've been in this situation just recently where they were giving me the extraction report on a piece of information while they were in possession of another extraction report that they did not give to us that became vital to the massive reduction in the case because of issues that made their Cellbrite extraction look poor. So what I'm basically saying is here, she's making articulable arguments, and she's going to ultimately force this judge on this issue, in my opinion, to have this hearing. Because right now this judge's main concern is not causing a reversal on appeal. So I'm kind of liking this from where I sit, because it's just like this individual citizen going up against this whole criminal justice system and a prosecutor and a judge. And I think she's doing okay, guys.
Well, you know, I mean, that is one way of looking at it, but I'm going to push back a little bit, Bob, because she has made multiple statements to media outlets that she really hates being in Arizona, and she hates the facility there in the jail, and she wants to get back to the prison setting one way or another. So maybe she doesn't like playing lawyer because she just wants to go back to prison in Idaho.
I don't know. I agree that she's making good arguments, Bob. I do think that she's making good arguments, some good arguments. What I don't like is her manner and personality or method in doing it, but a lot of attorneys, we don't necessarily care for their approach in court. Speaking of approach in court, Bob, how as a prosecutor would you prepare to try a case against a pro se defendant? Would you prepare any differently or do it the exact same you would against any attorney?
Yeah, that's a great question, Judge. No, it's a different representation. The first thing as a prosecutor that I'm going to be thinking of is I have to be very careful that my skill as a prosecutor, my oratory abilities, the manner in which I'm treating her in front of the jury is not seen as being excessive. I'm probably going to take some zip off the fastball where a jury sees two lawyers going at it. That's expected. If they get the impression that I'm beating up on her as a prosecutor, that could whipsaw against me. Now, that doesn't mean you back away. It just means you meet like force and you just don't go too hard. The other thing is, there could be a lot of things she brings up that are ridiculous, a lot of things that are not what we customarily would do. But in the cases that I've had like this, one time I was before a judge, I'm going to tell you my opinions changed. And I was like, well, she's held to the same standard, Your Honor, as any lawyer would be. And the judge kept letting the pro se defendant get away with this, that, and the other. And at the end of the trial, the judge brought us in and said, listen, I did that because you got your conviction. And now there's nothing on appeal she could say because I didn't limit anything that she wanted to do in her case. So to answer your question directly, Judge, I may also let a little more slide than I normally would with an attorney in the case, so there can't be that she was, while she's entitled to represent herself, that she was ineffective when she's able to do pretty much whatever she wants to do within reason.
And I would say as a judge, you're going to let some of the things slide that you otherwise wouldn't for the exact same back to court. Let's bring back defense attorney, former head prosecutor Bob Bianchi to discuss. How do you think the state is doing, Bob, in terms of the way it's laying out the evidence? Right now, it's really chronological. It's the very first person on scene, moving through each subsequent person, and now we're finally going to get to see pictures of the crime scene.
Yeah, presentation of a case for a prosecutor is essential, at least for me. I had it down to a pinpointed exact witness order, sometimes trying to put in the middle the less important stuff, but the things I have to do because legally I need to get evidence admitted and there's a certain chain of custody process. So you want your most important and powerful evidence to be in the beginning and the end, primacy and recency. So what the prosecutor's doing right here is being able to tell a story. So she's laying out the crime scene, and that is obviously one of the most important things. My experience has been the diagrams are very powerful because it's putting the crime scene into context, but when you start showing the photos, there's a real powerful realism that's going to be before the jury. It's going to be a riveting thing. It's something they've never seen before. It puts the crime into context. The photos are typically pretty jarring for individuals, and I'm not saying as prosecutors we want to jar people, but it really brings home the seriousness of the situation. So I think this prosecutor, from what I'm seeing right now, is laying it out in a very logical and consistent way, keeping in mind that we always have to, as lawyers, that what we know in our mind when I train trial lawyers doesn't translate to what they know. They're tabula rasa. So you have to start from the beginning and paint a picture step by step in as least a complex way as possible. And that, by the way, parenthetically, may I add, is why the opening is the most important part of a case for a prosecutor, because it allows this evidence to be put into context based on the opening statement.
Agree, absolutely.
That's why we need to see Bob try a case.
Absolutely, we're coming to visit.
Yeah. All right, let's head back in. Yeah, let's head back into court together, Bob.